Okay, now we're going to pick up example or exception 6 from the previous discussion. That is public authorities and statutory functions. Here, the imposition of a duty of care is very rare. It is very difficult to do for a whole range of reasons. Broadly, these are really social policy reasons again. The courts ask whether it is really appropriate for the court to be involved when what is really being examined or what is really under consideration is the exercise of a government power, the exercise of a power by the government that involves some kind of discretion, a decision to build a hospital or not build a hospital, a decision to include let's say, a resuscitation unit or a emergency unit in a certain clinic somewhere. These are decisions that government officials make, taking into account a wide range of considerations. And the question that the issue that the courts have difficulty with is intervening or imposing a duty on government when those kinds of discretionary decisions are being made by government officials. And so, for instance, that's if there's a typhoon. The roads are damaged after a typhoon. There's been flooding. Now, how is the government to react? The various government departments. How much resources, how much manpower do they have? They will have to make decisions and perhaps decide to do this first and then do that second and then do this third. But in the meantime, the one who is affected by the third issue or problem, maybe flooding or something like that, it gets injured. It's wow, it took 1 week and the government department did not come here to help me. I want to sue the government for the damage, the further damage caused. But you can see how those decisions may be made for sound considerations, or at least considerations that people might disagree about, but at least they are decisions that are being made by government officials who are trained to do so. And if you disagree with a decision being made, well, usually there are internal remedies within the government to try to find out what went wrong and to reprimand people. But these are services that are important, but they may not be something that the government can keep up with or deliver at a satisfactory level, satisfying all citizens at any given time. Now, that's one way of looking at it, but there are probably a broad range of policy reasons why, generally speaking, there is no duty of care imposed on public authorities in the exercise of their statutory functions. Now, you think about some of those examples: traffic lights, the maintenance of traffic lights or of roads, the provision of education, hospitals, rescue services. The courts have identified a number of policy reasons why no duty would be owed, generally speaking. And among them, these are just cited from various cases. Government or public bodies are providing services that are voluntary, that are really subject to budget, subject to discretion. They can be withdrawn at any time. It isn't a permanent or ingrained duty on the part of the government to always provide this service. And as an argument we've seen before is that if you do impose a duty in the way that those functions are exercised and services provided, this may cause the government body to act in a defensive way in order to merely to avoid being sued, avoid liability. We saw the argument being raised in Hill and Chief Constable. The so-called defensive mindset, which would maybe settle in with the public, with the government department, if it knew it might be sued for making a wrong decision. And generally speaking, the courts don't really like to interfere with government decision-making. I mean, we have a division of powers, as you know. You have the legislature, the executive, you have the judiciary, and they should be separate in a rule of law system. And so the courts are not exactly sure what is the right point where it would be right to intervene in government decision-making. And as I've hinted at before, there are internal mechanisms. There can be judicial review of the way that powers were exercised. And although this doesn't result in an award of damages to anybody who was injured, yet it does help improve and maybe discipline people who made a mistake and help improve the situation going forward. So, and there are other concerns. I mean, this is just a broad explanation as to why, generally speaking, it's very difficult to impose a duty of care on public authorities in the exercise of their statutory functions. But I wonder about some of that. Sometimes you hear the argument of service is voluntary. It's about omission, after all. It's a service or a provision of some service that is subject to withdrawal. And much of the time we see in the cases in which the government is sued that it appears that the plaintiff is really complaining about the failure of the government to act, to provide a good service. And that looks like omission. That looks like nonfeasance. If there was a typhoon and the roads have lots of holes in them, well, the government didn't put the holes in there. They are there. And if you're going to complain to the government that you didn't fix those holes, aren't you really complaining about an omission or nonfeasance? Now, this is often raised as an argument by government departments when they are defendants to explain why a duty should not be imposed on them. And if we consider the case of Michael and Chief Constable, which we have looked at already and we'll look at again, this is the case where a woman telephoned the 999 number in England because she was being attacked by her ex-partner who threatened to kill her. And the police the police call system took the call and wrongly understood her complaint and wrongly classified the phone call and did not put her call on an emergency basis by mistake. When the police did finally arrive at her home, she was killed already. She was dead. And so her family brought the action. And one of the justifications there for no duty of care being owed was that, after all, it's a mere omission. The police failed to provide protection to her. It's just like Good Samaritan law. We don't have one. But I wonder whether this is really sound reasoning, because when we talk about public authorities, departments, when we talk about the government, what are we really talking about? The government is there to provide these services. That's the only reason why we have government, is to arrange, organize, and regulate activities within society to provide for our needs, broad social needs, education, hospitals, rescue services. So for the government then to say, we don't owe a duty because, after all, this is mere omission, does not really seem to be a good justification. Mere omission may be a more palatable justification where we are talking about individuals. We're not going to require an ordinary citizen to confer benefits on others. But I think we do expect the government to do so. So this argument about omission doesn't really persuade, I don't think. But nonetheless, it's almost impossible to impose a duty of care on the government. Assumption of responsibility might be a relevant way to solve the duty problem if the government or the government staff, in any particular case where the plaintiff has sued the government, if the government staff can be shown to have entered into a relationship with the plaintiff, such as, for instance, adoption agencies, or examples where the government has to actually sit down with the citizen and meet and talk about the case. Now, in those cases, we might find it might be easier to impose a duty. It's a case-by-case thing, but there, maybe there is an assumption of responsibility, and maybe the argument for duty can be made. Now, what I want you to do for a moment, is I want you to reflect for a moment on the tutorial news report from Tutorial 5. You'll recall that this was about a 7-year-old boy, I think, who ran across the road. He was with his 10-year-old sister, but they were on their way to school, and the boy saw the minibus, ran across the road, and then he was knocked down by the minibus and dragged along, and he was injured. Now, you've already analyzed that in Tutorial 5, so we won't go over the issues that we took up. But I want you to reflect on part of what was reported in the news report. This was not relevant to our Tutorial 5 discussion, but you'll recall that the news report said that a police officer noted there was no pedestrian crossing facilities in the area. this suggests or hints at the possibility that there was a mistake, that there's some sort of mistake made by the Highways Department or by the Roads Department in failing to provide a pedestrian crossing there. And if it can be shown that this was really a mistake, then could a duty of care be owed? That is, duty of care owed by the government department to the little boy who was injured. And you can reflect on that as to whether a duty of care would be owed by the government. I'm not going to discuss it further now, but I'm going to leave it to you to consider, perhaps with reference to the 6 policy concerns that we just discussed concerning duty of care and public authorities. You can evaluate whether you think a duty would be owed. You can maybe review those policy concerns and identify which ones are relevant here. Maybe you can find out maybe some of them are relevant, some of them are not. What is the likely outcome if the boy was to try to also sue the government for the failure to provide safe pedestrian crossings in the area? I'll leave that with you. Now, I would like to look at one case in this area somewhat closely, and as an example of the government's approach, or rather of the court's approach when the government is a defendant. And I'm now going to talk about the case, the House of Lords case of Stoven and Wise, which is extracted on page 243 of your book. Their case is rather interesting. There was a motor vehicle accident in which the plaintiff was injured, and the plaintiff complained that the lines of sight at the intersection were very poor. There was an obstruction. There was a mound of dirt or something, so that when a car reached the intersection and tried to check whether traffic was coming, you couldn't really see. Now, the government, let's say the Highways Department has responsibility for maintenance of roads and making sure things are safe. And, well, the plaintiff sued the government department for having failed to make that place safe. And the facts were such that it was shown that the department had knowledge of that obstruction and had actually had a discussion about improving that intersection, but they hadn't acted on it yet. And it was too late for the plaintiff because the accident already occurred before the department acted on it. So it looks like the government, in this case, knew about the situation and started to act on it, but didn't quite execute. Here, the question is, well, would there be a duty of care owed for their failure to act? Again, it looks like omission, it looks like nonfeasance, but they were already aware of the situation and beginning to act on it. So perhaps it's a bit different than those other situations. Anyway, Lord Hoffman, in giving them majority judgment, took a fairly hard line, and I think this is where the law sits in regard to a duty of care being owed for public authorities' exercise of statutory function. And Lord Hoffman broke it into 2 questions that in this kind of a case. The first one being, was the government's decision to not act, or was it irrational on the facts? Would it be irrational not to clear that obstruction away? And on the facts, the court came to the view, no. That is because this was just one of many obstructions. There were many, many things that needed attending to in the area. It was not irrational to put this particular job on the lower end of the pile. That was the finding, and this is so the first condition failed, and then the second condition also failed. This is how Lord Hoffman put it. Are there any special circumstances justifying the payment of compensation to this particular plaintiff? And thought, no, just an ordinary member of the public. No special relationship, no assumption of responsibility. So, no, the plaintiff fails to prove a special case here for duty of care. And that is likely to be the way that courts would approach it in Hong Kong. We see in Hong Kong very few cases in which the government is a defendant, and some of them are outlined in your book. Yuen Kun Yew is one of them. Actions generally, or I guess you could say always, are failing against the government when it comes to the exercise of statutory functions or powers. Of course, the situation is different altogether if the government is being sued because of its negligent conduct in carrying out an ordinary duty, such as, for instance, a police officer drives a motorcycle or a police car. He's a public servant, so he is a part of the public authority here, And of course, he must drive his vehicle with due care, just like everyone else. And if he doesn't, then he causes a motor vehicle accident, he can be sued, and the government will be vicariously liable. So we have to recognize that there are situations where the staff or the members of a public authority may incur a duty of care because they are actually engaging in what you might call misfeasance. They're now driving a motor vehicle, or perhaps a doctor in a public hospital, a public doctor, is carrying out a surgery. This is misfeasance now, it's not nonfeasance, and so here the duty of care will be determined in the usual way without regard to the considerations that we previously discussed. We have to bear that in mind. And I posed a question here for you just to test your reading, make sure you're reading closely and carefully. You can read the question, and if you don't know the answer to that, then you should go back and complete your readings more carefully, because this is a special rule that applies in Hong Kong only, and you can find about it and read the justification for this rule.